For the first time in over 200 years of United States government history, Congress attempted to use its subpoena under its legislative power to get the documents related to the personal and business finances of the President of the United States. Thank goodness the Supreme Court did the right thing and told Congress to pound sand. Let's talk about why. Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we are talking about the separation of powers between Congress and the president and just what happened with those congressional subpoenas attempting to get the president's personal financial information from his accounting firms. Now, this is not talking about the criminal subpoena that's going on asking for similar information from one of Trump's personal accounting firms. That's a different case with a different outcome. This is just about Congress. But I want to reiterate that never in the history of our nation has Congress attempted to leverage its subpoena power related to the legislative process in such a way as to try to get the personal information of the president. This is a new issue before the Supreme Court, and it didn't really give them a lot to go on. They had to determine, basically with no real authority, what they should do in this situation. And they noted that neither side, neither the president's side nor the House of Representatives side, provided an adequate framework for how this should be handled. So they created a new one. They created a 4-step test. But let's real quickly talk about what this means. What does it mean to subpoena under the legislative power of Congress? All right. Congress has inherently the legislative power and the legislative authority granted by Article 1 of the Constitution. And this lays out all of the powers of Congress to legislate. At the end of the day, that's Congress's job. Create legislation, make law, and do so with some specific goals, providing for the common good and the general welfare of the people, providing for the common defense. All of those things are part of the duty that Congress has, and the legislative power is what allows them to do that. By making law, they go ahead and enact that mandate. Now, the executive branch's duty is to execute the law. That's why it's executive. That's why the Department of Justice and law enforcement falls under that executive authority. Congress makes the law, the executive branch executes the law, and the balance between those two things is really, really important. So, you may have heard of, subpoenas in criminal cases and stuff like that. That actually falls under the executive authority. Congress has no power to issue a subpoena for anything in related to pursuing criminal or justice-based outcomes. That's not their role. Their role in the subpoena power is limited to legislative purposes, lawmaking purposes. So all of the subpoenas that they issue, and anytime they're demanding someone to come and speak to Congress and enforcing them or compelling them to appear, that's all related to their lawmaking or legislative power. Now, there is a limited instance where something akin to a criminal justice subpoena may come into play, and that is when Congress is invoking its impeachment power, which is another one of the sole powers that Congress has, the power to impeach. Not just the president, but really any federal government official would be impeached properly under the impeachment powers of Congress. And they can issue subpoenas related to that impeachment power, and those could be valid. In this case, in the case before the Supreme Court, the subpoenas issued were not related to the impeachment of Donald Trump. They were related specifically, ostensibly, to the lawmaking power. That's what Congress chose to issue the subpoenas under, because they were not impeaching Trump over these documents, over this personal financial information. They weren't impeaching him over it. Therefore, they could not extend the subpoena under that impeachment power. But they've been wanting to get Trump's tax returns and other financial documents for a very long time. And the purposes that they have may actually be related to the impeachment. They may be hoping to uncover something that would allow them another step at impeaching Trump or even imposing some sort of criminal liability. But you don't get to go on a fishing expedition to try and get that information. They have to provide some level of evidence when the subpoena is contested to suggest that it is a valid exercise of their power and that it's related specifically to the objectives that they're stating. Okay, so that's what happened. The Supreme Court took a look at this and it determined that there was an improper purpose going on and that improper purpose violated something called the separation of powers. The separation of powers is how the branches of government, legislative, executive, and judicial, interact with each other in executing their mandates, whichever mandate each branch has, and how they interact with the other branches and how that power play balances out between them. And it's not an even balance. Each of them has some power and authority, but Congress is typically regarded as the most powerful entity, the president being second and the judicial being third, although that is debatable at times, but that's kind of the general thinking on the subject. That being said, the Supreme Court looked at this and says, Congress is trying to use its power in a way that violates or disrupts the separation of powers between the legislative branch and the executive branch. And so they did decide that this was an improper use of the congressional subpoena and that President Trump does not have to, at this point, turn over his personal financial information, or more appropriately, I guess, that his accounting firms are not required to turn over his personal financial information. Now, this did go through the lower courts at the district court and appellate court level. Both of them actually ruled in favor of Congress, saying that Trump should have to turn over those documents. And the Supreme Court now has stepped in and said no. Now, the main reasons are the separation of powers, but that's not really very helpful to courts going forward. And since this is a case of first impression for the Supreme Court, again, this has never, ever happened. They needed to create some sort of structure for courts in the future to use. And they did that by creating a 4-part test. Because what they don't want is a president to be able to say, nope, separation of powers, you don't get my personal financial information, because it's, I guess, on the outside chance possible that Congress could have a legitimate need for that information related to a legislative purpose. Or more importantly, they could have need for other documents that are not financially related to the president or not so private and personal. And they don't want the president to have carte blanche to go ahead and shut down a subpoena just because he's involved. So they created this 4-part test, and the summary of the purpose of the 4-part test is to create a balanced approach where the courts must take adequate account of the separation of powers principles that are at stake, including both the significant legislative interests of Congress and the unique position of the president. And so that 4-part test is as follows. First, the court should carefully assess whether the asserted legislative purpose warrants the significant step of involving the president and his papers. Basically, can Congress get this information from anywhere else? Is the president and his personal papers, is that the only place Congress can go? Because that's a significant impact on the separation of powers. Next, to narrow the scope of possible conflict between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. So the subpoena cannot be overly broad. It must be focused down to get the exact things that Congress wants and no more, because recognizing, again, the personal nature of this information. Third, courts should be attentive to the nature of the evidence offered by Congress to establish that a subpoena advances a valid legislative purpose. So they don't just get to say, well, we have a legislative purpose. They have to provide some evidence to show why they need this information in particular from the president in his personal papers. That's a pretty big step. Congress has to not just assert its legislative purpose, but to back it up with some evidence. And they're instructing the courts to carefully consider that evidence. And then fourth and finally, courts should assess the burdens imposed on the president by a subpoena, particularly because they stem from a rival political branch that has an ongoing relationship with the president and incentives to use subpoenas for institutional advantage. So they're recognizing the inherent nefariousness of a competing branch of government leveraging personal information of the president and saying that they have some sort of power to extract that information and then potentially use that in a politically or personally damaging way. That would give Congress a leg up over the executive that wasn't actually designed within the Constitution and would run afoul of the notion of separation of powers. So that's the whole idea here. That's what the court is trying to prevent. And that final prong of the test instructs that specifically with regards to the president, there's a lot of vulnerability here that needs to be taken in where a court might otherwise not take that factor into consideration. So that is the 4-part test that the Supreme Court has developed, and that is how they'll be handled going forward. But they really didn't do anything beyond that because, as they stated, this is the first time this has come up in over 200 years of history. They don't have a lot to go on, and they probably won't see another case like this for a while. Although I think that might be naive, as the partisan politics kind of get more and more polarized. We'll probably see more and more encroachments onto the personal aspects of people's political opponents under their supposed powers of the legislative and executive branches. So the court has stepped in and said, this is a bridge too far and we need to shut it down now. And they've sent it back to the lower courts for reconsideration with that 4-part test in mind. So we'll see what happens next. Now both parties are going to go back and argue that under that 4-part test, this either does apply or doesn't apply. And then the lower courts will issue their ruling again, and it'll probably go back up the chain. And that's kind of how these things go. So I hope you guys found this helpful, educative, informative, and that it kind of clears up what's going on in a digestible way with this ruling, and why it was an important thing for the Supreme Court to actually step in and decide. And we do have to give them credit when they made the right decision. Congress should not be able to just go after the personal information of their political rival president. That disrupts the whole process, and it also runs afoul of just the principles behind things like the 4th Amendment, your right to be secure in your personal papers, possessions, and effects. And that extends up to the president as well as down to us plebeians here at the low level. So thank you guys for watching. I hope you enjoyed this. If you did, please like, share, subscribe, all of that stuff, and leave a comment below about what you think. Have a great day. Peace. Peace.